Good day, I'm Police Major Rigel Can P. Manzanes, your Legal Officer of Legal Assistance Division, your Pañarong Police Supervisor, and your Legal Officer of DIDM. Today, we will discuss DOJ Department Circular Number 15 Series of 2024, otherwise known as the 2024 Department of Justice and National Prosecution Service Rules on Preliminary Investigations and Inquest Proceedings. In our jurisdiction, there is two-stage process of criminal proceedings. First is under the Department of Justice, which consists of preliminary investigations or inquest proceedings. On the second stage, it is with the judiciary or the trial court judge who will try the criminal case. These new rules modify almost the entire stage of the criminal proceedings. This new rule supersedes the rule on preliminary investigations and inquest proceedings found in the rules of court. Then it took effect on July 31, 2024, 15 days after its publication. As to policy, this new rule is consistent with the policy of DOJ to file information in court only when prima facie evidence with reasonable certainty and conviction is established. This new rule institutionalizes the following policies. First, the executive and inquisitorial nature of the conduct of preliminary investigations and inquest proceedings. Second, the proactive role of prosecutors in the investigation of crimes. And third, the adoption of procedure for e-filing as well as the conduct of virtual preliminary investigation hearings and e-inquest proceedings as alternatives. This new rule covers the conduct of preliminary investigation or inquest proceeding for crimes or offenses where the penalty prescribed by law is at least 6 years and 1 day without regard to fine. Prima facie evidence with reasonable certainty of conviction exists when a prima facie case is established by the evidence at hand, including but not limited to object evidence, documentary evidence, and testimonial evidence. Such evidence, if left uncontroverted, shall be sufficient to establish all the elements of the crime or the offense charged, and consequently warrant a conviction beyond reasonable doubt. The quantum of evidence is met when the prosecutor is convinced that the entirety of the evidence presented by the parties is admissible, credible, and capable of being preserved and presented. Reasonable certainty of conviction also includes a summary evaluation of the evidence presented by the correspondents through their counter-affidavit. Under the new rules, dismissals may be justified on account of admissibility and credibility issues even prior to a court trial. This new rule also integrates the case build-up and assessment process institutionalized in DOJ DC 20, Series of 2023. One question will arise on this new rule. Who are authorized to conduct preliminary investigation and inquest proceedings? All prosecutors, including prosecution attorneys mentioned under RA 10071 and other offices as may be authorized by law. Likewise, state prosecutors shall have jurisdiction over crimes or offenses where national security is involved, task forces have been created, venues were transferred to avoid a miscarriage of justice, and state prosecutors directed by the Secretary of Justice to take over as public interest may require. The city, provincial, or regional prosecutors and their assistants shall have jurisdiction over crimes or offenses and violations of ordinances cognizable by the proper courts in the respective territorial jurisdiction. Who are the parties involved in this criminal complaint? The complainant and respondent. The complainant is the offended party or person authorized to file the complaint affidavit on behalf of the offended party or a law enforcement agent or other public entity charged with enforcement of the law violated. The respondent is the party being charged. These are the general flow of preliminary investigation. The complaint affidavit is filed at the appropriate prosecutor's office together with the duly accomplished NPS investigation data form and other supporting evidence that would establish prima facie evidence with reasonable certainty of conviction. The head of the prosecution office will assess the complaint for sufficiency in form and completeness of evidence before the complaint is docketed. If the evidence is insufficient, the head of the prosecution office will require the complainant to submit lacking evidence. The complaint will only be docketed and sent to an investigating prosecutor if the head of the prosecution office determines that the complaint is sufficient in form and the evidence is complete. Upon receiving the records, the investigating prosecutor has 5 days to determine whether to recommend the dismissal of the complaint or to issue a subpoena to the parties to appear for the preliminary investigation hearing. A dismissal can be recommended if the investigating prosecutor finds no ground to continue with the investigation. During the preliminary investigation hearing, the respondent may file his or her counter affidavit. The respondent need not appear in person if the counter affidavit was sworn to before any prosecutor, any government official authorized to administer an oath, or in their absence, a notary public. The case is considered submitted for resolution upon receipt of the counter affidavit and confirmation that the counter affidavit has been received by the complainant. However, the investigating prosecutor may opt for clarificatory hearing or submission of reply affidavit and rejoinder affidavit, or discovery procedures such as subpoena judice tecum or ad testificandum. The head of the prosecution office or the designated prosecutor will provisionally determine the validity of the warrantless arrest before the referral is docketed and assigned to an inquest prosecutor. The arrested person will be ordered to be released if a warrantless arrest is invalid or if the required evidence is not submitted within the relevant periods under Article 125 of the Revised Penal Code. Inquest referrals must be resolved within the same day and transmitted to the head of office for approval on the next working day. The referral will only be docketed and assigned to an inquest prosecutor if it is determined to be complete in terms of the required evidence and establishes the elements of the crime, and if the periods under Article 125 of the Revised Penal Code were shown to have been observed. Thank you so much. That is all for DOJ Department Circular Number 15, Series of 2024. Once again, I'm Police Major Rigel Can P. Manzanes, nag-iiwan ng mga katagang, lamang ang pulis na may alam.